You are listening to the Julie Parker Practice Success Podcast, where you discover management insights and strategies for a successful dental practice. There are also interviews with key people in the industry who have advice and services to help you and your team achieve great success. Welcome to this week's episode of the Julie Parker Practice Success Podcast. And we have got another fresh face from resident legal firm Burke Associates down here in Melbourne, although they do look after everyone all around Australia. And we've got one of the principal solicitors at the practice and accredited property law specialist, Kristy Muhlhan. Welcome to the program.
Thank you, Julie.
I really appreciate you joining me around property law and how it impacts dental surgeries. I'm really intrigued about this space.
Yeah, look, I thought it would be helpful to explore setting up a dental practice, but as it relates to premises.
Yeah, very interesting. So tell me about the topic in general.
So I thought that we could give a few examples of dentists wanting to set up their own practice. So that might be acquiring a new property, it might be developing an existing property, or it might be leasing someone else's property.
Fantastic.
Yeah, so perhaps we can start with an existing premises and go from there.
That sounds great. I'm going to have questions all the way through, so be prepared to be peppered with them.
All right, so I might start with an example just to show, I suppose, the practicality and how it might impact someone's decision-making in terms of finding a premises. So let's talk about a situation where someone already has an existing residential premises and they're looking to convert that premises into a dental practice.
Yeah, it's a pretty common scenario, isn't it?
It is. So it's more common probably than people think, but it is really common to convert premises. I suppose the first step in setting up a dental practice would be to make sure you do your due diligence to understand the location, planning requirements, including the zoning of the land, and make sure that you can actually undertake what you want to do at those premises.
Yeah, so I imagine that's right. You need to make sure that you can zone it for the services that you want to provide. So the zoning is number one. Parking, of course, parking restrictions or how many parks you're allowed to have on a particular location as in terms of how many surgeries that you can put in on that location. That's the other key consideration as well, isn't it?
Absolutely. So when we're talking about planning permits, there's various different permits that you need. So you've got the use of the property, which is you want to run a dental practice from those premises. You then have car parking requirements, which may have different planning requirements. You have signage requirements. And then separate to that, there's a consideration of whether you'll be developing or subdividing the land or, constructing something new on the land, essentially.
Beautiful, because quite often, we start out buying a dental surgery. If we're converting it from a residential premises into a dental surgery, that often happens in the early stages of one's dental practice ownership career. And you just want to get to point A. You want to be able to establish yourself there, have patients come through and build a viable business. But being a consultant, of course, and seeing this kind of scenario play out so many times, if you're good at what you do and you get a good team around you, you're in a good area, quite quickly your aspirations go a bit larger.
Oh, absolutely. And I think this is probably one of the points where sometimes you're so caught up in the moment of starting your practice, you don't take a step back to consider, can you actually run this sort of business from the premises that you want to? So there's different planning requirements with the use of the property. And sometimes it might be that there's just a blanket, no, you can't run a dental practice from the premises. Sometimes it will be, yes, you can, but you need to meet certain planning requirements and get that planning approval in place. And then in other circumstances, depending on the zoning, you may just be able to operate your business without having a planning permit in place at all.
Okay. And what sort of, if people have identified a location and they've got aspirations to build a practice at that place, of course, before they purchase that building, they need to make sure they've done their due diligence, as you've said, and found out whether they will be able to actually run a dental practice from that location.
Mhm.
I know there's probably not a dollar amount, but what sort of outlay are they looking at to investigate with the local councils and, coming through lawyers like yourself? What sort of outlay are they looking at just to investigate whether they can actually even open their doors?
Well, a starting point would be just to contact the local council and talk to their planning department to find out a little bit about the zoning of where the property is actually located. So that doesn't really come at any cost apart from a time cost in terms of investigating that. But then I suppose, depending on what the council tells you, you'll get to a position where you may want some legal advice or town planning advice just to confirm that what you've been told is accurate, or perhaps to help you interpret what the council has indicated may be required. So, as a really sort of rough guide, you might be looking at, $1,000 or $2,000 for that initial investigatory stage, and then following that, there may be further requirements that flow from that.
And I suppose it's all worth it. Getting all that information is worth it because you're trying to mitigate as much as possible any risk to you building a viable practice as possible. And whatever you can do prior to opening up your doors, that's going to serve you very well going long term. It will reduce so much stress going forward.
Absolutely. And what a lot of people don't realise is if you don't set it up correctly at the outset and outlay those costs, sometimes it can end up costing a lot more in the long run when you're trying to work backwards and fix everything.
Yeah, money well spent, as they say.
I think so, yes.
So what's the next stage?
Okay, so next stage is you have looked into the zoning, you either need a planning permit or you don't need a planning permit. Obviously, if you need a planning permit, then you need to make that application to council. We can assist in that process. Alternatively, you can engage a town planner that can often assist in that process. So hopefully the planning approval stage goes rather smoothly so long as you've met those requirements. From time to time, if you're trying to do something slightly outside of the planning scheme, then there may be an application required to VCAT, but that's probably unlikely unless you're trying to change something that's not already in the planning scheme and allowed.
Okay.
So once you have your planning approval in place, other considerations will be, what do you want to do with the property? Are you intending to do, for example, an internal fit out of the property? Is it already in, a condition that you can use for your dental practice? Do you need signage? Do you have sufficient car parking requirements? So all of those things should be considered in a planning context as well. And depending what the answer is to those, you may need a different planning permit as well, or perhaps a building permit if you're doing substantial construction works.
Okay, so do they need actual final plans of whatever reconstruction you're planning on doing within the building to be able to make a final approval?
So it would depend on the extent of the fit out. So, obviously, if you're just doing some minimal works, you might be painting the premises or, putting new carpet in or something along those lines. Then you're probably not required to get planning or building approval for something along those lines. But it's more if you're looking to do substantial works, for example, extending the floor area of the building, changing anything structural or anything like that. Yeah.
Okay. And I suppose if there were structural changes to it, and putting a second story on, you'd have to do that whether it's residential place or a business anyway, I imagine.
Absolutely. Yes.
Beautiful. Okay.
And that's where you would engage with the building consultant to assist you in that regard.
Tremendous.
Yeah, so once you have your premises set up, other considerations will be, well, firstly, do you own the premises or are you leasing the premises? So if you were leasing the premises, you then need to put in place an appropriate lease or sublease depending on the premises. Depending on the premises, you might need a lease in place, or if you're looking just to establish your practice, for example, renting a room in an existing medical practice, it might be that you need a sublease or a license in place instead.
Okay, yeah. And, it's interesting, spending money on the structure of your practice when you are leasing the premises from somebody else. Some people may think, oh, I'll only do that if I actually own the building and then I get to benefit from all of that. But the larger your practice is, or the better the fit out, so therefore the more productive and efficient it can be, one of the huge winners of that is the business itself. It's turning over more money because it's either more productive or more efficient.
And I think that's probably where negotiating the lease terms is really important as well. It's really often that agents will negotiate the lease terms. And as a new tenant, if you haven't previously leased a property before, you might think to yourself, oh, these are the terms that the landlord is offering. It's a sort of accept or walk away type scenario. But that's often not the case. So often there is the ability to negotiate the terms that are more favourable to you. So it's just about knowing the things that you can negotiate on and, giving it a go essentially.
Yeah, and I agree with you wholeheartedly. I think getting a lawyer in to represent you when you are negotiating these leases, I think, again, money well spent, because you are stuck with that lease for a long period of time. And you want somebody who deals with this information all the time and understands where you can benefit more so if there were just slight little changes within that lease. That is a very prudent step.
Absolutely. And I think just understanding what you can and can't negotiate on. For example, if you're intending to do an expensive fit out of the property, you might be able to negotiate a 2, 3, 4 month rent waiver so that you're not actually paying rent while you're doing your fit out. So you can definitely save costs if you know where and how to negotiate. So it's definitely worth taking the time to understand that.
Perfect. And places like yourself, Burke Associates, can also help in that step as well.
Absolutely.
Beautiful.
And then separate to that, so that's obviously leasing the whole of a property, but there are other options as well, such as renting a room in a property, which may be by way of a sublease or a license agreement. And often you can also negotiate for a service and license agreement where, for example, a general medical practice might be able to offer reception services, billing services, and so on in exchange for licensing a room to you.
Yeah, and getting the specifics down in that lease is important. I mean, you've really got to think about the daily operations and the things that could potentially rise up as issues, such as how many car spaces one practitioner is using over yourself, and where you've got a certain right to a number of car spaces, and certainly when you're sharing the work capacity of a singular person or a singular entity, and to make sure that you are being, that you are fully utilising that lease to the best of your benefit as well.
Absolutely. And then separate to that, obviously, if you own the property, you need to consider whether you need to have a lease in place as well. So you can't have a lease with yourself, but it might be that you establish another entity which may be more advantageous from a tax perspective rather than just occupying your own premises without a lease in place. So I would definitely recommend in that scenario to get some tax advice and see if it's more beneficial to you to set up a different entity to occupy the premises, to run the business of the dentistry practice, as opposed to the entity that actually owns the property.
Oh, very good. And as a bit of a side thing, that lease, how careful do you need to be with that lease? Can that be like a basis for any future leases with a different dental practice if they came in and purchased yours, or can that lease be quite basic?
So you do and don't have to be careful. If it's just your business and there's no other third parties involved, then yes, you should have a legal document in place to record the terms essentially, and that will also assist from a tax perspective. But if you're the one running your business and there's no other parties involved, it doesn't really matter what those terms are because you have the ability to change it if you're in control of those entities. Where it becomes more important is if you're wanting to sell your business, for example. So at that stage, before you put your practice on the market for sale, it would be wise to go back, have a look at that lease, understand the terms, see if you want to perhaps surrender that lease and enter into a new lease, which perhaps is, on more market terms so that it's more persuasive or more valuable to a purchaser.
Beautiful, beautiful.
Another consideration might be if you're looking to purchase or perhaps lease a property that's not yet constructed. So you might be aware of a development in the area where they're building some office suites that might look like a good location to start your dental practice from. So with something like that, what we see from time to time is that agents are not necessarily familiar with the legal documentation required in such a scenario. And often a lease, for example, would be signed at that stage, even though the property is not actually constructed and doesn't really exist at that point in time. So it's also important just to be aware that there is different legal documentation required in that circumstance, because essentially you're agreeing to enter into a lease at a future date at the time that that development's completed. So
that feels scary to me. What happens if you go in the walls are made of paper?
but there are benefits as well. I mean, what we often see is, there may be a property developer that's building this new building. They want to retain, the retail spaces essentially, but they want to lock in a tenant early on so that once it's complete, there's a tenant ready to go. Now, in that situation, it might be that you, who has a dental practice, you want to take up possession of one of those properties. You might be able to negotiate to get your fit out completely done by the developer in exchange for locking in that lease. So there can be quite some benefit from
now I feel more comfortable with it. I wouldn't mind that. Well done. And I suppose as with everything, there's benefits and drawbacks. There's two sides, and you end up, understanding both sides very well and making the best call in the moment.
Absolutely. And I think that with anything, you should always be undertaking some sort of feasibility and working out, what are your goals? What's your short-term strategy? What's your longer-term strategy? Where do you want to get to? What's the growth in your own business and what are you trying to achieve? Because that, if you can understand that, that will help you in making an informed choice and, selecting which option is better for you in terms of acquiring, leasing, developing land, whatever it might be.
And have you come across some scary stories that you can share with us that are examples of what we should try to avoid?
Well, I think one of the most common things is people lease a property without understanding the planning requirement. So something that we've seen in the past, for example, is, I'm going to lease this property. It's been a general practitioner medical centre for the last 10 years. So, it should be right type thing.
The old Aussie saying, it'll be right.
It will be right, yeah. So having a look at the existing use, you might make the assumption that your use is okay, but without actually going back, looking at the zoning, understanding if there is a planning permit is in place, it's quite dangerous to make that assumption, because even though a dentistry practice falls within the definition of a medical practice essentially as a land use term, it doesn't mean that what the previous business has been doing is compliant essentially. So it's always important to make your own investigation and not make any assumptions.
For sure. Never assume someone else is being completely law-abiding.
That's right. And particularly if you're a tenant, a standard lease puts the onus on a tenant to make sure that they have the appropriate approvals and consents in place. So you might actually be in breach of your lease by failing to undertake that due diligence to begin with.
Yeah, I can imagine that. And so the responsibility, as like with everything, when you own a business, it all lands at your feet.
Absolutely. Absolutely. So, a landowner will do everything to protect their own interests, not to protect your interests. So as a business owner, you need to make sure that you're doing the right thing and, dotting the I's, crossing the T's, making sure that you're doing everything properly.
And I think that's where the enormous value and peace of mind comes when you do get legal advice on your side with all of these sort of complex issues. Like what you just said, the owners of the property are going to be doing everything to make sure that they are being looked after, not you are being looked after, but that they are being looked after. There's somebody needs to be in that ring for you and who understands it.
Absolutely. And often people will think that the agent is sort of acting for both parties, when they're really not. So agents are engaged usually to act for the landowner in the negotiation. So they're going to be protecting the interests of that landowner or the landlord. They're not going to be looking out for your interests. And that's why it's important to get someone impartial involved. If you don't understand it, I mean, you may have done this 10 times already. You may completely understand the process and what's required, and you may be able to represent yourself in such a transaction. But if you don't, or if it's the first time going out in a venture like this, it's really important to have someone on your side that understands it.
So some of the elements around a lease agreement, some of the core basics you want to get down pat, I imagine one of them is the term of the lease. And so whether it's 5 by 5 by 5 or what sort of term of the lease do you advise many of your clients? I suppose it depends on what their dreams and aspirations are. But if they're looking to go into a location for a long period of time, a permanent period of time for their career, and you're always being aware that whenever you change location, you always risk losing a few patients in that change of location.
Yes.
In terms of the terms of the lease in length, what's your advice around that?
So it's not that we would advise to go with a particular term or not. I think it really depends on the person's circumstances and what they're trying to achieve. So, for example, someone who's already operating a dentist practice is looking to perhaps expand, grow their business, and is looking at moving to a larger premises. If they've already got quite an established business, it might be that they're wanting to secure, a long-term lease to make sure that if they're going to be spending money on another fit out, for example, that they might be there 10, 15 years, 20 years, whatever it might be. So for someone in that situation, it would probably be worthwhile negotiating a longer-term lease. Now, that could be structured in many different ways. It might be that there's an initial term of 2 years, 5 years, whatever it might be, but there might be several options available so that if that party is happy to remain in those premises, they have the option to extend that lease term. So it might be 3 5-year terms, for example, making a total term of 15 years. So that's probably quite standard in terms of established businesses. But then on the flip side of that, you might have someone who's looking to start a practice fresh. They might not have, a big following. They may be starting off on their own, sole practitioner essentially, and looking to grow that sort of over a longer term, provided everything goes to plan. So in a scenario like that, it might be that they only want to give it, 1 or 2 years to see how that business goes and then make a decision of whether to make it long term, or they might think to themselves, this isn't working, I want to get out. So in that scenario, you'd be better off trying to negotiate a shorter initial term, so maybe 1 or 2 years, but then also having options available where if it goes well in those first couple of years, they then also have the options to stay in the premises and exercise those options. So I think it's really a balancing act of really what are you trying to achieve, and do you have an existing business that's growing well that you want to expand, have long-term tenure in a premises, or are you wanting to play it by ear a bit and see how it goes?
Because what are your options if you were in the middle of 2 years into a 5-year first-term lease, and you thought either, gosh, we're growing so big, we're so successful, we need to get out of these digs, or you are brand new and going, oh, my God, what have I done? I don't want to do this anymore. And you need to get out of that lease. How difficult is it to get out of the lease?
Ultimately, it will depend on who you're dealing with, who's the party, who's the landlord. Is it someone who, firstly, is the premises in a really good location where it would be really easy to replace the existing tenant if they walked away? It might be that the landlord's happy to let you go because they may have a list of people waiting to get into those premises, and perhaps they might even get, a higher market rent at that point in time if they let you go. So it really comes down to location and landlord, really. In that situation, it becomes about a negotiation. So you either need to negotiate to get out of the lease, or potentially you can find a new party to transfer the lease to take over those premises. But once you're locked into a lease agreement, it is a legally binding document. So unless you have agreement with the landlord to alter that, you're stuck in that lease essentially, and you would be in breach if you decided to vacate the premises and
run away,
leave, essentially. Yeah. So in those circumstances, you wouldn't want to go down that path without notifying the landlord, because then you're at risk of being sued and all sorts of things as well.
Yeah. And what if you were in a position where you were growing and expanding, and so you were so as a practitioner, I've got a particular scenario in my mind that's come across my table of late, and they've grown, they're in an existing lease, they're looking at relocating to another location. They don't want to damage the relationship that they may have with the existing landlord, but they still want to be fair and give him enough notice of their future intentions. Are there additional amendments that you can, or attachments you can make to an existing lease that still assure you of the time? I mean, the lease itself assures you of that full length of time. If you just needed an extra 6 months or just an extra year until, that's taking you to kind of refit out the new location you're about to move into, are there further negotiations that you can do in addition to the lease that can help protect both sides?
Absolutely. So number one, you can always negotiate. You can always reach an alternate agreement to the legal agreement that's already in place. So again, it's just about communication between the parties, and hopefully the parties are on the same page so that you can negotiate, what you want to achieve. But ultimately, if your initial term runs out, your only options are to renew if there's any further terms offered in that lease, or otherwise you can stay in possession of the premises on an overhauling basis, which generally means that either party can give 30 days notice to vacate. So you would be better off in those circumstances where that initial term has ended, and if you want to stay on, say, 6 months or a year rather than, say, 5 years, you're definitely better off trying to negotiate that with the landlord, and then you can enter into a deed of variation to record that agreement.
Okay. And when you're initially, because I imagine this would be more difficult to do once you've already established a lease and you're renewing an existing lease, but when you are establishing a fresh lease, is there negotiating space for adding into that lease that the landscaping will be refreshed every 5 years or something like that the landlord will be making some sort of effort to make sure that the facade of the building is updated in any way? Or is that always going to be the owner of the dental practice, their responsibility to do if they wanted to do it?
No. So again, anything can be done by agreement. It really comes down to what's that negotiation at the outset and what's been agreed and what's reflected in that lease document. But there's no reason why a landlord couldn't do that.
Beautiful. And I know that when I had my practice and whatever I wanted to do on the inside, the landlord was great. He said, if you pay for it, you can do whatever the hell you want, which is fantastic. Yeah. And so sometimes these conversations that you have in a friendly way with your landlord can make you think you've got permission to go forward and do such and such and such and such. But you need to always reflect back into your lease, because the lease itself is the thing that's going to end up being in front of a judge if anything should go wrong.
Absolutely, yeah. And I think that's right. That's what people forget, is it's not a casual document. A lease is a legally binding document. So if the lease doesn't say that, you can paint the premises whenever you like or do whatever works you like, if it doesn't expressly state that in your lease document, then there's potential for dispute to arise later down the track if you're just relying on a conversation that you had. So even if it's not in the lease document, I would be always recommending put it in writing, get that agreement, an exchange of emails, exchange of letters, that can still be considered a variation to the existing agreement. So get it in writing to protect yourself.
Fantastic. And from that lease perspective, are there any other things that come up in your mind now that people really have to make sure that they get covered off in that lease?
Look, there's nothing specific that needs to be covered off. All I would be saying is just understand your rights, understand that you have the ability to negotiate. Another example that comes to mind is ordinarily a lease is structured on the basis that you pay rent and you pay outgoings. That's sort of relatively standard. Just because that's standard doesn't mean that's required. So you could negotiate, for example, a gross lease, which would mean that, any amount that you pay is inclusive of outgoing, so that it's a fixed cost and, you know exactly what you're paying. So just little things like that are, important to consider. Something else that comes to mind, rent review. So each year that the lease not renewed but comes to the anniversary of the commencement date, usually a lease would provide that there's some sort of rent adjustment. Now that could be a fixed increase, for example, 3%. It could be a CPI increase, or it could be a market review. So somewhere in your lease, you should consider whether you want a market review in there. A market review is really helpful in circumstances where you might have fixed increases, say, over a 5-year period, and you get to the position where you might actually be paying rent that's more than the market value. So if you had a market review somewhere in there, you have the ability to bring the rent back down as opposed to it always increasing. So that's just something else that you could consider.
Beautiful. Well, yet again, it's another area where we're better off getting a specialist to help us on our journey. And I really do appreciate Burke Associates coming on again and helping us out with another topic. I encourage all listeners to the podcast, if you've got specific topics that you would like covered in the future by Burke Associates, please let me know. Just email me anytime. My email details are in the show notes, as Kristy's email details and Burke Associates website details are in there as well. So do jump on there if you are in a position where you need some legal advice and guidance. And of course, all the information that Burke Associates discussed with me on the podcast is all just for information only. None of it is legal advice. Thank you, Kristy. I really do appreciate it. I hope you come back on the show again soon.
Great. Thanks for having me, Julie.
Hey, if you enjoyed listening to this episode, you should join the club. The club members receive an online lunch and learn every week where I share insights, systems and strategies to improve the success of your practice. These lunch and learns could not be easier. They are recording so you can watch them at a time that suit you. Members also have full access to the library of all of our past topics. It is a powerful and effective way to upskill your team. I hope to see you there.